Welcome everyone, my name is Forrest Wan and I'm the group leader of Group 7 from TT6L. And I will be explaining the copyright part for this video. The intellectual property will be explained by Jishan, Danish will explain the patent part, and Jalal will explain the trademarks. So let's go to the first part, which is the intellectual property that will be explained by Jishan.
Good evening, ladies and gentlemen. My name is Kishan Kumar, and today I'll be giving the introduction to our discussion today. Let's get started, shall we? So our first stop is the core of our discussion, intellectual property. What exactly is intellectual property, you might be asking? It encompasses works of the mind, like ideas, inventions, technology, arts, and more. These are creations that individuals or groups can claim ownership to, leading to potential economic gains as rewards for their initial investments. Now, let's delve into the rights associated with intellectual property. Intellectual property rights are also known as IPR, are legal rights bestowed upon creators, often in the form of patents, trademarks, and copyright. These rights protect both the moral and economic aspects of the creator's work. Importantly, legal protection is granted only to the tangible, fixed in some tangible medium, such as books, papers, machine, or processes. Intellectual property laws provide ownership to the right to control and produce physical manifestation of their work. There are various forms of intellectual property, each serving a unique purpose. This includes copyright, trademark, patent, industrial design, geographical indication, and layout design. Each of them offering specific legal protection tailored to different types of intellectual creation. Why protect intellectual property, you might be asking? It's not just about the ownership, it's about fostering the innovation and creativity. The benefits are twofold. For individuals, it safeguards the rights of the creator to be compensated for their valuable, intangible, and creative work. On a more social level, it promotes fairness in the business dealings, encourages research and development. Okay, I think now that's all from me. Thank you.
Things I'm very good evening. My name is Danish, and now I'll be talking about the thing called patent. So what is patent? What's the definition of patent? So patent is actually an exclusive right granted to an inventor, which help innovates in a way of doing something or solve or create an invention of solving a problem. So that's the definition of patent. And second of all, what's the process of patent in Malaysia? So patent in Malaysia is technically developed by my IPO, which stands for Intellectual Property of Corporation of Malaysia, under the Patent Act of 1983. So therefore, it prohibits people from copying other people's invention. If they do copy, then they will be against with like class action lawsuits against them. So yeah. Third of all, the patent criteria. So there's three. First and foremost, it could not be a general patent. It should cover an invention that should not be a general knowledge to the people, to a human, especially like for example, it's a basic knowledge where everyone knows like how to do it. So patent couldn't cover that. And the second of all, the patent, the innovation cannot be disclosed to public yet. Like so, like the patent, the public hasn't known about the invention of what you have created. So it has to be kept secrets before it releasing to the public. Finally, it is able to mass produce industrial-wise. So if you cover these three criteria of patent, then you can apply it for patent. Well, let's get into utility innovation. So utility innovation, you can see it as a minor thing like compared to patent. It's the same but also not as detailed as patent, where innovators or applicants can apply for either patent or utility innovation. Both are ushered by my IPO, and Malaysia follows a strict-based first to file rule, where the first one to file the application would get the exclusive right to the innovation. Yeah. So now we get into the length of the protection of patent. So basically for patent, it lasted 20 years from the date of filing the patent, not from the date of approval. And also the same as utility innovation, where utility innovation, it takes around like 10 years plus 5 years plus 5 years. So basically the approval, you have to wait for 2 to 5 years. That's why they grant you the ownership from the date of you filing and not the date of the patent being approved. Yeah. Next, from what I understand regarding software patent, where in United States, it will protect like functions and embodied systems inside computers, so software can be patentable. But in Malaysia, however, a computer can claim to be itself, so it's a record. Therefore, it's unpatentable. Where there are some solutions, there are some exceptions. I'm sorry. Where if I'm reading here, like from my research, it says that though if there's a technical contribution to the prior art, such as program-controlled machines, manufacturing, or process, then you can apply for patent of the software. But two things: what happens if like you copied someone else's invention, where you in patent infringement case, and what happens in cross-license agreement. So let's talk about patent infringement case. Let's say if you copy someone else's invention, you're going to get a class action lawsuits against you, and you will be brought up to the High Court, where you could be faced to pay up around 3 to 10 million US dollars of damages, and they will reward it to the person who wins the case. So because yeah. of what you do. Second of all, let's talk about like cross-license agreement. This is usually between companies. Usually you'll find in companies. For example, these companies want to make a profit without actually meddling in the patent infringement. So for example, they will have a specific contract. A company will hand over a specific contract where like they can use their some of their products, and in exchange for them to give something from their side as well. Now let's talk about something interesting regarding defense publishing. Defense publishing, you can say it's like a patent where like you can file it as a patent, but in a way which is cost effective, which takes a couple of hundreds of dollars, and it doesn't require any lawyers, and you don't have to wait for like a couple of years to wait like for the approval such as patent. So this is where like you publish your description of your innovation as prior art. So basically, therefore people cannot use like your innovation. If they use, they're gonna get class action lawsuits filed upon them. Yeah. Let's shed some light in an issue called patents trolling and standards. So patent trolling is a broadly used thing, usually from firms where they applied for patent of manufacturing, but without using the patent, like without actually having an intention of manufacturing anything. So these are accepted by the standards of de facto by the industry. Also common, for example, is submarine patent, where they hide the patent processes with standards until it's broadly adopted. Yeah. And in my research also, there's another strategy called patent farming, where it's influencing standard organization to make use of patented item without actually revealing its existence and demanding royalties from the party. Let's talk about a fun fact where there's also a thing called patent wars. Believe it or not, yeah, there's patent wars. So patent wars, for example, basically it's like both companies trying to like apply for class action lawsuits against another company. For example, between Samsung and Apple, where like Samsung filed lawsuits against Apple where like sliding the lock screen kind of detail, and then like the mobile device related details where they start off other companies copying what they are doing, so they're originally doing. So it goes on and on until 2018 where they have a settlement. Rather than prolong the litigation, they actually conclude of trying to make profit both them. Patent ownership, it becomes different when it comes to employee and employer, because let's say if an employee in a company creates an invention, so of course the law follows where whoever creates the invention, they are the ones that are eligible for the patent. But let's say if like the employee use the employer's tools or something regarding the company's thing, so it vests in the employer to give the right to the patent to the employee, or they claim it for themselves. Even though it doesn't mention in contract, just now the contract it didn't disclose fully about this kind of stuff, but yeah.
Now let's discuss about copyright. Copyright is an exclusive right that granted to the creator of the original works. So it's basically providing them with control of various aspects of its use, also the distribution of the original. Under copyright, the owner is granted with exclusive right for a specific period. This encompasses control over the reproduction of the original work in any form, including photocopying and recording. This also extends to performing, showing, playing the original work, communication, distribution by sales, transfer of ownership, or commercial rental, that including the public, must be known by the creator of the work because they have control over it, because they have the copyright exclusive. It's crucial to understand a key concept in copyright. An idea cannot be copyright, but the expression of the idea can be copyright. This means that the unique way an idea is manifested in creative work can be copyright and protected under copyright. Copyright protection in Malaysia is governed by the Copyright Act of 1987. Interestingly, unlike patent, there is no formal registration of copyright for copyright. However, copyright owner can opt for copyright voluntarily notification as a method to establish and notify their rights. The duration of copyright protection is dependent on the type of work. For literary, artistic, and musical work, it lasts the life of the author plus 50 years after the death. Broadcasts have a protection period of 50 years from the first transmission, while film, derivative works, and songs recording, they are safeguarded for 50 years from publication or fixation. However, with great protection comes great responsibility. Copyright infringement is unauthorized use or reproduction of someone else's copyrighted work, such as text, image, or video, without permission. This not only violates the exclusive right of the copyright holder, but also subject to legal consequences. Some of the act of infringement is including reproducing the original work in any material form, showing it, playing it, performing it, and distributing it to the public, importing foreign article into Malaysia for trade or financial gain. This type of act of infringement can lead to legal consequences. Infringement occurs when the person claiming can show that the defendant has committed a copyright infringement. In simpler terms, the burden of proof lies with the person claiming that their copyrighted works, has been infringed by the defendant.
Now let's turn our focus to the fascinating world of trademarks. A trademark is any icon that could be represented graphically. The purpose of trademarks is identifying certain goods and products from one undertaken from those of others. Trademarks comes in various forms, such as traditional trademarks like letters, words, names. We also have non-traditional trademarks like shapes, colors, scents. We also have holograms trademarks. Understanding the function of a trademark is essential. Trademarks are supposed to help identifying the origin of a product, which help consumers make informed decisions. Unlike copyright, trademarks duration are calculated in a different way. It begins with the filing date until 10 years. Sadly, after those 10 years, there's no option to renew. As for the importance of registering trademarks, we have a couple of points to clarify the important. Owners of registered trademarks enjoy exclusive rights, which give them the sole authority to use those marks in commerce. Furthermore, they have the legal right to pursue legal actions against anyone who used their marks without permission. The registration document issued by Register's Office serves as evidence for ownership of trademark. This document is very crucial, especially when you want to establish ownership of goods that are exported to other countries. That was everything from me, Jalal Usmantala. Thank you.
In conclusion, I encourage you guys to delve deeper into the world of intellectual property and its various aspects. Seeking professional advice and respecting intellectual property is not just about legal obligation, but also it's a key driver into the innovation in the society. So thank you guys for joining us on this journey into the world of intellectual property. Bye-bye.